Before Canada became a nation in 1867, its legal framework was inherited from England. Back then, common law, judge-made law, was the backbone of justice in all of the British colony. This system emphasized precedents enabling courts to adapt decisions over time. Have you ever wondered where the phrase, my day in court comes from? My day in court. I want my day in court. If you have, then you're in the right place. If you don't know what the phrase is about, you're still in the right place. And we're going to talk about that. Welcome to the show. My name is Cash, and I am excited to have you join me. And today we're going to talk about one of the most important, fundamental, key principle within the legal proceedings or world in Canada. All right. And what are we talking about? I want to talk to you today about procedural fairness. What is procedural fairness? How that impacts Canadian law, and why that matters to you. If this is your first time on this platform and joining us, welcome. We are happy to have you here. iChat Law is a platform that seeks to improve and inform individuals within our community about access to justice and how to make access to justice more affordable in this case, right? So imagine, for example, being denied a passport or fired from your job or even deported without ever getting a chance to tell your side of the story, right? That's the reality when procedure fairness is ignored, right? And today we are going to unpack one of the most fundamental principle in Canadian law: the right to a fair process. So from the Supreme Court of Canada, and I'm going to be relying a lot on some of the fundamental cases or the key landmark cases that impact the process. We will explore how the doctrine protects your right, whether you are in court, at a tribunal, or even before a school disciplinary board. Your right to a fair and reasonable hearing is premised on this particular legal principle, right? So, what is the most common misconception about this principle? The most common misconception about this principle is that, it's a delay. It minimizes or it slows down the process. But we'll get to that in a few minutes. For now, let's talk a little bit more about what this principle or what this legal principle means and represents. With Confederation, however, a federal court wasn't initially created, but provincial superior courts handled most serious cases. It wasn't until 1875 that the Supreme Court of Canada was founded to unify legal interpretation across the provinces. Inherited from England, judicial review allowed courts to invalidate laws that conflicted with superior statute. The turning point came in 1982 with the Canadian Charter of Rights and Freedoms, empowering courts to strike down laws that violate fundamental rights. The Charter's due process protection means courts must ensure fairness, notice, and hearing before an impartial tribunal based on the 14th Amendment principles from elsewhere adopted to Canadian values. So, this long-standing legal foundation gave rise to the procedure fairness, a concept meaning a case is doomed because a critical procedural error, like lacking jurisdiction or failing to provide notice, renders the process void. Simply put, if fundamental fairness is compromised, nothing that follows can stand. Within law, we sometimes refer to it as natural justice. Which is to say that this principle governs the entirety of any judiciary process, and it's the backbone of any decision-making entity or government institutional decision affecting your rights. So what I'm proposing to do is, let's start by looking at it from a rule, sort of a point system, right? So there's two parts to this rule. The right to be heard, that's you get a meaningful chance to respond to whatever allegations being made against you. And the right to an unbiased judge. No one with a stake in the outcome should call the shots. Pretty much it. But how flexible is it? The Supreme Court of Canada says fairness is a context specific. What is fair in a criminal trial may differ from what is fair in a labor dispute. So let's dive into the 5 non-negotiable principles. And as you can see it rolling out here, we're just going to go through all of them, right? And the 5 principles basically governs the way this particular rule is deployed. Okay, procedural fairness is not an abstract idea. They are hardwired into the Canadian legal process through landmark cases, and so here are sort of a toolkit to bear in mind. Number 1, and notice you have the right to be informed. You need to know what is going on. Okay, and the Supreme Court of Canada case that enshrines that doctrine is the Baker case. A mother facing deportation wasn't told her humanitarian application will be decided by a skeptical officer. And the Supreme Court of Canada simply ruled that hidden biases and lack of notice violates fairness. Let me say that again, slowly. Okay? Fairness requires an opportunity to respond. So one cannot bring a case before a court with the competent jurisdiction of the matter without a notice to the person who is being affected by this matter, right? Fairness requires, and this is a key component of this particular principle. Fairness requires an opportunity to respond to potentially damaging allegations that have been made against one, right? And if the evidence is damaging and potentially can get you into a huge legal risk, the higher the requirement for that process to be enforced, right? Number 2, the hearing. Your voice matters, okay? and Supreme Court of Canada in Singh versus Minister of Employment Immigration, 1985. I'll put more details of these cases that I'm referring to in the notes, where in this particular case, refugees were denied oral hearings. And the Supreme Court of Canada basically said that the Charter of Rights sections, particularly Section 7, life, liberty, security, demands a chance to be heard, even if it slows down the system. Okay? So tribunals essentially has to radically restructure themselves to meet the requirement. But today, delays are sometimes weaponized against claimants. Is that undermining fairness? We'll talk about that a little bit later. But it's important to note that Committee for Justice, that's the case that relies on what a reasonable observer who basically have no bias against the matter and have no stake in the matter, right? Like, for example, a regulator who previously worked for the company they're investigating cannot then become the adjudicator of that company, right? Now, This may also come as a bit of a surprise to most people because they go, yeah, but for example, the Canadian Forces has their own tribunal, and the Canadian Forces is the beneficiary if they decide against a claimant who usually is a member of the Canadian Forces. Again, in some cases, there are checks and balances put in place to ensure that people and individuals going through proceedings like that are given a fair hearing, right? And so, notwithstanding the fact that in some organizations and in some tribunals, it would appear that people who also have an interest in the matter are also sitting in judgment, there are usually a legal sort of protection to ensure that the individual gets their fair hearing. And so one of the things that I do, for example, when I get a matter, and I deal with a lot of Canadian Forces members with claims and particularly Section 29 grievances. And Section 29 is the National Defense Act. Section 29 provides a mechanism by which Canadian Forces members who have a grievance against the force can bring their matter. And in this process, there are mechanisms put in place to ensure that the individual rights are protected. In most cases, some people don't actually know that they have those rights, and those rights are protected. So, and this is one of the reasons why we are having this conversation, right? Including such topics that involves recent controversies over political appointments to tribunals. All of those things matters, right? Now, number 4, this is very important. Reasons. The why behind the decision. Val v. Love. That's a 2009 Supreme Court of Canada decision. A citizenship application was denied without a clear reasons. And the Supreme Court of Canada slapped this down and essentially said decisions must be logical, justified, to allow potential appeal processes to take place, right? It also forces transparency, but lower courts still struggle with this. And in some cases, this is a reason for appeals. Okay. Number 5, representation. Representation matters. Okay. And again, most people take it for granted, and the assumption here is that I can represent myself. But in fact, in law, you have the right to represent yourself, but you also have the right to delegate that right to represent yourself to somebody who is more competent. This is where lawyers come into play, right? The Supreme Court of Canada case that establishes this rule is the New Brunswick versus GJ 1999 case. A parent in a custody case couldn't afford a lawyer, and the Supreme Court of Canada essentially said fairness may require a state-funded counsel in high-stake cases, which is the point I was making earlier on. This isn't automatic. Courts balance the complexity, the stakes, and your capacity to represent yourself. But in most cases, without a doubt, you still retain that capacity to represent yourself, no matter what the complexity is. But you also can ask for help, especially if the more complex the matter is, the more the courts are required to accommodate you. Okay, so let's get practical. When does fairness clash with efficiency? Take immigration, for example. In the post 9/11 security certificate era, most government actors detain non-citizens on the basis of security, the blanket security concerns, and in some cases, people basically would just deny any procedure of fairness, as I've enumerated in this particular episode, and in 2007, the Supreme Court of Canada in Shakoak versus Canada called this fundamentally unfair when people are denied the very basic notice and disclosure of evidence so that they can have a chance to be heard. And sort of the balance is ensuring that the governments can still protect their citizens, but also not to sort of have secret hearings without any opportunity to respond to allegations that have been made against individuals or group of people. And so that accommodation also include, hearings, and sometimes through Zoom, sometimes through including providing interpreters to ensure that people clearly understand. And that brings me to, for example, even the language. For example, in Canada, we are a bilingual country, which means that we have two official languages, French and English. So if you're a Frenchman and allegations have been made against you and brought to a court, you are entitled to ask for a French court, a French judge, and a French communication or process that allows you to be able to express yourself properly. Same thing if you are an Anglophone and the matter is being brought to you by somebody who is French speaking. That person is obliged and required to provide you a interpretation or a translation of the matter, so that you would have a fair. Again, it's all about the fairness of this process, right? If you are not, let me make this point clear. If you're not giving notice, if you're not being given disclosure of what the matter is, you can't respond to it. It's as simple as that, right? And so to be able to effectively respond to the matter, you ought to be given these protections and these guarantees in terms of the process, right? Anyway, so that essentially sums up procedure fairness, right? Now, we are going to have more detailed conversation about how this works, and perhaps, use some very specific examples, and that way it will become more clear. But essentially, the key point or the key takeaway points is that, one, procedure fairness is non-negotiable, right? Especially the higher the risk, the higher the stake, the higher the legal risk to the individual, the more procedure fairness is needed, and to ensure that nobody is treated in an arbitrary manner without any right and capacity to be able to respond to these or whatever allegations be made against them. Anyway, I hope that was helpful. And if you want more detail, and if there are specific questions that you want to ask, just put them in the comments. And if this is your first time joining us, thank you. We appreciate you being here. We hope that you keep joining us and participate and join in our conversations. There are more details that is going to put in a notes session. That the goal is trying to help you as much as possible. By the way, if at the beginning we had a disclaimer, and I'm going to repeat the disclaimer. Everything we've said today, everything I've talked about today, is to inform. This is not a legal opinion. If you require a legal opinion, please contact our office or reach out to a lawyer's office and ask them to help you. Okay? Thank you, and we'll see you on the next one.